Dear students, GPS CLAT Academy at Gyanodaya, a senior secondary school at Sikar, supports its students in their CLAT preparation. We have started a lecture series which will be delivered to you on a daily basis on YouTube. The lecture series revolves around discussion of mock papers. You can request us for the concerned mock papers. If you intend to join us in our daily discussions, you are most welcome.
Section 13 talks about divorce. There are a number of grounds which are listed for divorce. If you make out those grounds, then you are entitled for divorce. But if you are not in a position to make out those grounds, then in a contested divorce, your application for divorce fails. And what are those grounds? Just briefly have an idea of what is a contested divorce and what is a divorce by mutual consent. I may just advert to all this. Any marriage solemnized by the before or after the commencement of this act may, on a petition presented by either husband or be dissolved. The dissolution is there by decree of divorce. And what are the grounds? The grounds are these. After the solemnization of marriage has a spouse who is living. So after the solemnization has voluntary intercourse with any woman other than his or her spouse. Right? And so that is one. Then has after the solemnization treated the petitioner with cruelty. So cruelty, ground of cruelty is another one. Right? Then has deserted the petitioner for a continuous period of not less than 2 years. So desertion, that is another ground. Cease to be a Hindu by conversion to another religion, this we already discussed. Because the moment you cease to be a Hindu, you cease to be a what we call as the court ceases to have jurisdiction over you because the Hindu Marriage Act applies only to Hindus. Incurably of unsound mind, suffering continuously from mental disorder, and so on and so forth. And then suffering from venereal disease in communicable form, that is another one. Then renounce the world, renunciation is the renunciation of the world, has not been heard alive for a period of 7 years, right? That is another one. And these are basically the grounds for divorce, right? In a nutshell, if somebody asks me what are the grounds for divorce, so again I say that if you have if you don't, if you disregard your conjugal relations and responsibilities to each other, that is, have extramarital affairs, that could be a ground for divorce. Cruelty, wives or petitions often complain that the daughter-in-law receives cruel treatment in the husband's house, spouse's house, at the hands of the grandmother, at the hands of other relatives of the husband, and so on and so forth. That is another one. Third one is conversion to some other religion because the court loses jurisdiction in that case. Then incurable disease, whether mental disease or whether some venereal disease, sexual disease, strong in communicable form. Then he is there is nothing has been heard. Desertion is there for 2 years, or he has not been heard alive for. He has not been known to be alive for 7 years or so. So these are basically the grounds for divorce. Now the legislature felt that these grounds for divorce are not sufficient. Sometimes the parties may be of the temperamental inconsistencies or the temperamental disharmony may be there between the parties, and therefore there is a necessity for creating yet another ground for divorce, which is mutual consent divorce. In mutual consent divorce, you don't have to make out any of these cases or eventualities. You just have to present a petition that we have stayed together, or that we have been staying separately, that it has not been possible for us to stay together for the past 1 year, and that we have decided to dissolve our marriage as per our convenience. I'll just draw your attention to the section. Here is the section. Subject to the provision, a petition for dissolution of marriage by a decree of divorce may be presented to the district board by both parties to the marriage together. So the petition has to be presented by both the parties, solemnized before or after the commencement of marriage, so on and so forth, living separately for 1 year, that they have not been able to live together and they have mutually agreed that the marriage should be dissolved. So three requirements are there: living separately for 1 year, they have mutually agreed that the marriage should be dissolved, and it is not possible for them. They have not been, they haven't been able to live together, not been possible for them to live together. What is the procedure? First petition is put in the court, then order is granted on that petition, and then the second petition comes in. In the second petition, there is a timeline that 6 months you have to present the second petition. This is given in the second paragraph. Not later, not earlier than 6 months after the date of presentation of petition, and not later than 18 months. Petition is not withdrawn, the court shall be satisfied. So the second petition comes after 6 months. After 6 months of the first petition, that we have been living separately, we have not been able to live together, and that our marriage should be dissolved. After the first petition is first round is over, then 6 months wait time is given to the parties. 6 months wait time is given to the parties, so that the parties may have, if they want to have a rethink, then they can have a rethink, and then the court may not proceed with the parties may not proceed with the contemplated divorce, mutual consent divorce. Instead, they may start living together. In that hope, the legislature has granted a time of 6 to 18 months, a phase of cooling down when both the parties reconsider their mutual positions and then approach the court with a second petition. If they don't approach the court, matter comes to an end, divorce proceedings are nullified. Then nothing more is heard on the issue. But if they approach the court once again and state that, look, still we can't live together and we have decided to finish or terminate our conjugal relationship, then the court examines whether the petition has presented with collusion, or the parties are playing fraud upon the court. And the court usually does this by calling each one of the parties separately and talking to them and trying to understand from them what is the reason behind the divorce. The courts usually also counsel the parties to stay together and not to break their marriage, because breaking the marriage is not in the interest of the society or in the interest of children if there are issues from the wedlock. So these are basically the consideration. Therefore, there are two kinds of divorces. One is the contested divorce and another is the mutual consent divorce. And the considerations in the two divorces are very, very materially different. In contested divorce, basically the parties are allowed to prove their case, and on certain grounds recognized by the law. The grounds are that they are unfaithful to each other, or either party is unfaithful to each other, that there is cruelty, that there is insanity, or there is venereal disease, or there is a desertion for 2 years or more, or there is renunciation of the world, or the religious, or some conversion to some other faith. Basically, these are the grounds on the basis which a contested divorce petition is granted, if the petitioner is in a position to prove that. But in a mutual consent divorce, none of this is required. All that is required is you have to say that we have not been able to live together. It's not possible for us to live together. It is not possible for us to live together at all. So, and then the procedures have to be followed, and the petition is granted. Now, in this case, the contested divorce is treated on a higher footing, and mutual consent divorce is treated on a lower footing. In a contested case, the natural implication will be that if the woman is seeking a contested divorce, then maybe the right to public employment may be denied to her. If you go by the ruling of which is presented, or the arguments which are presented on the other side of the fence, that if it is a mutual consent divorce, then we will not give you employment. But if it is a contested divorce, then we will give you employment. Now, in that case, if the contested divorce is on the side of the woman, will you tell her that you applied for divorce, therefore we will not give you the employment as guaranteed to you under the statute? So the court has reasoned that, look, this is not done. The women, when they undergo these proceedings, Then the women, when they undergo these proceedings in a conservative society like ours, no woman is happy seeking divorce from her husband. The judicial, what is going on behind the judicial mind, the official reasoning seems to be that you can't impute motives in every case, that every woman, when she approaches the government for a job after mutual consent divorce, means there is something in it, and the job is, the divorce is a sham, and basically they are trying to defraud the public policy by entering into some kind of collusion. They may keep living together and still remain legally, their status may still be of a divorcee couple. So that is what the article talks about. Having said that, let us take the questions now. Yes, this is Raj and Sita married couple decide to avail government job for Sita, and that to that end, this now you see, to that end, this is what is being said here, that they decide to terminate their marriage, so that to that end decide to avail government job for Sita, and to that end they decide to terminate their marriage. So it is collusive, it is fraudulent, therefore this will not be granted, right? Chaliye aage. Mamta, after obtaining a divorce through mutual consent under Section 13B of Hindu Marriage Act, applies for a government job under the divorced woman category. Her application is rejected for delay. Now the ground is for delay. If your mutual consent divorce takes place, say on date X, and you come on X plus 10 years, then there is the necessity for a job. There is no necessity for a job, so you have defeated the right on the basis of delay. So that is why the application is rejected. And since the cause for rejection of the application is not mutual consent divorce, but the reason is something else. Therefore, there can't be any exception that can be taken to this, right? The article prohibits, but the article does not prohibit other kinds of reasons which may defeat the entitlement, right? Then you come to question number 95. Sunita has separated from her husband for 6 months and both agree to get a divorce. When they consult a lawyer who advises them to file for mutual consent divorce, they accept the advice and file for the divorce. Decide on their application in the first round. So what is going to be their first round application? Separated from 6 months. Now the legal requirement is what? The legal requirement is not of 6 months. Separation legal requirement is for more than 6 months. What is the legal requirement? Can you look into the paragraph and tell me how much is the legal requirement? Can you just look into the paragraph and tell me how much is the legal requirement? That for the you and your spouse can go to court if both of you have been living separately for more than 1 year. So the requirement is 1 year. The separate living must be for 1 year. And how much is this? 6 months. So what is the court likely to do? The court will not issue notice. They may keep, if the judge is very kind to you, he will keep the application. And he will keep the application pending, saying that you come after you fulfill the period of statutory compliance, right? That kind of thing the court may give. The court may take it up and then give you a date of 6 months, thinking that you should not be put to the trouble of refiling it, and he doesn't want to dismiss the application and force you to file it again. So he may keep it on the file, keep it this thing, and give you a date of such time that the legal period is satisfied. There are various ways in which judges can really help litigants. Now, when they consult a lawyer, so this is very clear. They should have come after 1 year. They should not have come after 6 months only, because that is the legal requirement. Procedural requirement has to be met. This is 100% correct. I am very happy. 96. Then 97, once again, very happy I am. Then 97 also, 98 also, same. Then 99, I'm not sharing the tab. 99, 100% correct. Very nice. So, nothing. Please come to 16.
So this passage talks about protection of public servant. Uh, The Supreme Court has ruled that public servants were protected from the prosecutions without prior government sanctions, and even if they exceed their official power, as long as their action has reasonable connection to their duties. Section 197 of CRPC and the Section 170 of Police Act Public Servant public servant cannot be prosecuted without prior sanctions unless their actions completely unrelated to their official duty. Even an act linked to the official functions, the officials still retain protection. No sanctions is required for the serious crime like rape, sexual harassment, stalking. There is a case PK Parzan versus State of Sikkim. The accused can raise the um, defense of lack of sanction at any stage, even after convictions, but uh, but must prove the act was part of official duty. And the similar to the section 197, but now require the competent authority to decide the sanction within the 120 days, uh, or it will be automatically granted. And giving accused an opportunity to explain the situation to magistrate and obtaining a report from the accused superior officer. Strengthen the protection for public servants performing their duties and prevent misuse of official power for personal gain.
Yes.
And, and also ensure accountability while avoiding unnecessary harassment.
Supreme Court ruling, in which the Supreme Court has ruled that the public servants they can't be prosecuted without government permission, and even if they are accused of exceeding their official powers, as long as their actions are linked to their official duties, they can't be prosecuted without government permission. And this protection comes under the section uh, 197 of the CRPC, and section 170 of the Police Act. And the court said that just going beyond one's power doesn't automatically remove the protection, unless the act was clearly wrong and had no connection to official duty. And this protection is not available if a public servant uses their position to commit serious crimes like rape, sexual harassment, human trafficking, or any other grievous offenses. And in such cases, no prior sanction is needed to start prosecution. And the court referred to past cases like PK Pradhan versus State of Sikkim, and explained that an accused officer can claim the need for sanction at.
So, what is happening here is that the government servant, you must have noticed, suppose you go to a police station and there the SSO says that I will not register your complaint and I will not book an FIR. You make an allegation that, or you go to a judicial office and the judge misbehaves with you, or you go to the collector's office or to some other office or Tehsildar's office or STM's office or some other official's office, and those people basically show inaction in taking up your calls, or they are negligent in doing their duties. Can you bring an FIR against them? Is it possible? Can you register an FIR against them? You can register a complaint against them. But can they take cognizance of the complaint? The answer is no. Suppose you are wronged by a police officer who has named you in an FIR, whereas you had nothing to do with the offense uh, which is disclosed in the FIR. You have nothing to do with it. You are not even present on the scene of the crime. But out of ill will and malice, the police officer basically takes your name inside the FIR. And unfortunately, this ill will and malice is very, very difficult to prove, because the moment you allege ill will and malice, the court starts looking at it with suspicion that you have an agenda against the officer. So, ill will and malice, very easy to allege, but very, very difficult to prove. How do you prove ill will and malice? Very, very difficult to prove, unless something very glaring happens. So, you say that my name has been carried into the FIR, whereas my name could not have been carried into the FIR by any stretch of imagination, and yet my name is carried into the FIR. And you, for this kind of intentional implication into a crime situation, you start you submit a complaint against the police officer and SHO, the police officer in the station house, that is in the police station, and you register a complaint against him, and an FIR is also registered against him. And can the judicial magistrate take a cognizance of the FIR? You have suffered. You have suffered very grievously. Or suppose a police officer catches hold of an innocent person and throws him into the jail and keeps him there for 48 hours beyond the time that has been sanctioned uh, before production of the person concerned before a judicial magistrate. Can you register an FIR? Yes, you can give a complaint. But will the courts act upon that complaint? The courts won't act upon that complaint. This is what it is saying. Courts won't act upon that complaint. Why? Because of Section 197 of the CRPC. What is Section 197 of the CRPC saying? This is what it says. When any person who is or was a judge or magistrate or a public servant not removable from his office, save by or with the sanction of the government, is accused of any offence alleged to have been committed by him while acting or purporting to act in the discharge of his duty, no court shall take cognizance of such offence except with previous sanction of the central government if the employer is central government, and state government if the employer is the state government. So you can understand what kind of blanket powers have been given to these people. These people have very vast powers. The public servants have very vast powers. If they are purporting to act in pursuance of their lawful obligations, and in the course of such obligations they egregiously violate, shockingly violate shockingly trample upon your rights, then still you may not have any remedy against them. And this is what is exemplified by this article, by this newspaper article, which says that if they are acting within the course of their duty or purported to be acting within the course of their duty, and in that case you will not have any recourse against them. What is the reason behind this kind of thing? Does it not violate Article 14? Why this kind of special treatment? When a private person violates another person's duty in the course of his business, does he have a similar protection? The answer is no. He doesn't have any protection whatsoever. Why he doesn't have any protection whatsoever? Because Article 14 says, and I'll just quote it once again, bring it to your attention, because you should always refer to the article even if you know it by heart. The state shall not deny to any person equality before law. So equality before law is not to be denied. Or the equal protection of laws within the territory of India, equal protection of laws. So if you are running your business, you have to run it in such a manner that you don't trample upon others' rights. That is what if you look at the powers of a private individual who is running a business, say powers of Elon Musk, who is running his business across several continents, and whose budget may exceed the budgets of various many countries. If you compare the powers of public servants with those, then you'll find that there is a lot of difference between the powers of public servants and private businesses. Both of them, in a way, lay down the law in the sense that there is a contractual law, that private law that these private companies also lay down. When you are in private employment, you are bound by contractual obligation, that is the law. So the parties have given to themselves the law of employment. Whereas in case of a public servant, he is there because of his entitlement, which has been recognized under the law. And both of them are discharging certain functions which are required by the kind of activities they are supposed to do. One has a lot of protection, another doesn't have any protection. What is the justification? The justification is that equality among equals. They are treated as two different classes. Private businesses are treated as one class, although they also create laws for others. And the public servants or public bureaucracy also has the duty of enforcing the laws. Therefore, they are treated as two different individuals in the law. They have different kinds of treatment in the law because they are regarded to be not equals. Equality is among equals only, not among. You can't compare apples with pineapples. That is the logic behind this. Therefore, when a public servant is discharging his duty, the idea is that he should be able to discharge his duty without any fear of tomorrow having to face a prosecution by the person against whom he gives the ruling. Therefore, some protection has been granted to him that if he is purportedly exercising his power under the statute or under the executive directions of the government, then in that case he will be protected in case certain people he gives an adverse ruling against certain people because he can't please everyone. He has to displease certain people and he has to grant the relief to certain people. And in that process, a judge can't say that I will keep both the parties happy. One of the parties may be unhappy or both the parties may be unhappy. The nature of the judicial act is like that. Nature of the official act can be like that. It can displease all the parties or it can please. It rarely pleases all the parties. It will surely it is more likely to please one of the parties and to annoy another party. And therefore, the another party which is annoyed should not be allowed to recoil against the judge or against the public servant and make allegations that look you have acted maliciously. Once he discharges his office, discharges the duties of his office pursuant to the statute or pursuant to the rule or regulation, then he has the protection. This is what it says. And when he has the protection, then in that case, still there may be cases when his conduct may slightly go beyond what he has the protection. For example, if an SDM has been ordered to disperse the crowd, and the crowd is really very unruly and it is assaulting the public servants who are taking steps to disperse the same, and they know that minimum force will have to be required, otherwise the crowd will easily overrun them. Then in that case, they start taking recourse to firing, and some of the people get hurt, but the crowd is dispersed. Now, in this case, the instruction was not to open fire, but then fire became necessary in order to quell the crowd. Otherwise, larger public interest would have suffered. So, this kind of slight what we call as this kind of flexibility is granted to them in achieving the objective. So that's why this protection. Now, this protection is often misused in the sense that suppose a public servant has taken bribes, and now the problem with this is that bribes, if you have taken them, you have for prosecuting him you require the sanction. So if the sanction is withheld, then sometimes it can create a problem that look you require the sanction to prosecute him. If the sanction is not forthcoming, then in that case he gets unpunished. So this can easily get arbitrary in the sense that if the public servant is on good terms with the government, he may get away. But if he falls foul of the government, then he may run into trouble, right? That kind of thing. But nevertheless, this is a protection that is given to the public servants, and across various jurisdictions, this kind of protection exists. And the reason behind it is that the nature of the job is such that the protection may have to be granted. Otherwise, if the public servants become very shy or very timid in performance of their functions, then they may not be able to effectively curb the problems for which they are there. They may not be able to discharge their problems. They may not be able to discharge the duties of their office. Now, this sanction of office, this sanction, government sanction, may an objection may be taken at any time of the proceedings, at the initial stage, at the trial stage, or a later stage, that the entire trial was vitiated because the sanction was not there, and the entire trial would come to a standstill. but the law provides the liberty that you may you may you may uh, you may file a fresh complaint once you have the sanction. That kind of thing is there. So having said that, let me come to the questions, and the questions are here. uh, this is 100% correct. 98, I guess. Yes. So I need not stop here. 98 is also 100% correct. 99 also correct. Then this one is not correct. A senior public servant, Rajendra, is accused of voyeurism after planting a hidden camera in women's washroom. A victim files a complaint. Rajendra argues that prior sanction is required. Is prior sanction? No, it is not required because it is against women. No prior sanction is required against crimes against women, crimes against trafficking in human beings, voyeurism, stalking. All these are considered to be very, very serious offences, very, very heinous offences, and therefore absolutely no sanction is required. Officer Sunil, while conducting a demolition drive, is accused of using excessive force against civilians. I have not shared it. Leading to severe injuries. Denying during the trial, he argues that his alleged actions were taken in course of official duties and raises the issue of lack of sanction. The complainants contend that this argument should have been raised earlier. No, it is very clear that argument can be raised at any stage. It can be raised during the trial also. It can be raised at the time of taking cognizance. It can be raised at the time of issue of summons. It can be raised at any time. There is no bar. Once you have this kind of immunity, the law grants you this kind of immunity, then the immunity cannot be taken away merely because it was not taken at a particular stage in the trial. So that is or stage in the case. Then that is not there. Then there is 103. A magistrate is considering taking cognizance of an offence alleged against a public servant. What steps must the magistrate take before the proceedings? So what steps are required to be taken? Issue summons to the accused immediately. Those are the steps. Examine the complainant and witness on oath. Provide the accused an opportunity to give explanation. Obtain a report. If you see the amendments which have been carried out in the BNS, right? Certain amendments have been carried out, and those amendments are given in the last para. If you have a notice, first proviso to 223 of the code prohibits a magistrate from taking cognizance without giving accused an opportunity of hearing to explain the situation which led to. So first a hearing has to be given. Don't take cognizance straight away. BNS has made certain changes. One is the sanction to prosecute must come within 120 days. Or if it doesn't come, then it will be understood that the sanction is granted. That is the change that BNS has made. Why this change has been made? This change has been made so that it doesn't happen that the entire trial is over and then public time and public resources are wasted in conducting the trial, and then it becomes apparent that, look, there was no sanction. Therefore, to avoid that kind of situation, BNS has inserted a proviso which says that, and BNS has inserted this, directs the competent authority to consider a sanction request under 120 days. So, sanction request has to be received within 120 days. If in 120 days the government does not grant the sanction, it means the sanction is deemed to have been granted. So that is one change that they have, which is a very, very salutary change. Because if the sanction comes after the trial, then so much time is wasted, so many judicial resources, so many resources are wasted. So that situation is taken. Second is that the accused has to be given an opportunity to explain what happened, what is their version of the story. And then his department, you have to approach his superior with their version of the story. Thereafter only they will proceed with the case. Otherwise, they will not proceed with the case. Therefore, this question that issue summons to the accused directly. No, examine the complainant and witness on oath, basically, and then provide the accused an opportunity, not oath, opportunity, and then obtain a report from the department. So those compliances have to be done. Then a citizen 104, a citizen challenges the constitutional validity of 1 kilometer, violates 14 high. No, this you have already done. So please come to passage number 17 now.
So this article is basically about the rights and benefits senior citizens get and the eviction power they have under the Maintenance and Welfare Act of Parents and Senior Citizens Act 2007. So the key points of this act is that senior citizens who classify as senior citizens, meaning above age of 60, and are unable to maintain themselves, are able to file for maintenance from their children. And that this act also places the obligation of children on the children to ensure that the basic necessities of the parents are fulfilled, such as food and medical care. This act also grants the power of eviction to the parents. So, if the senior parents feel that their hair or their child is not taking sufficient care of them, then they can use their rights under the Senior Citizens Act to order eviction, which will be tried under a tribunal, and then a eviction order can be passed. So, in a case mentioned in the article, a child, a eviction notice was given to a child taking care of his parents. So, a tribunal was set up, and that tribunal had ordered that his presence be limited to a single specific room and a shop in the property, and that's not all cases are. We must first look at the evidence. If it is truly mistreatment from the child side, then can they be evicted from the house. Otherwise, they can have restrictions placed on them how they move in the property.
So this passage talks about the senior Supreme Court ruled that senior citizens cannot automatically evict their children under the Maintenance and Welfare of Parents Senior Citizen Act 2007 unless there is sufficient reason to do. Parents aged 60 and above can file a financial support from their children if they cannot maintain themselves. And the Act does not grant evictions right, but the court have interpreted the Section 22 to allow the eviction in certain cases. If a senior citizen uh, gift or transfer uh, property and with the condition the receiver must provide the basic need and failure to do so can be invalidate the transfer. And the court previously ruled that tribunals can order evictions if necessary for maintenance and protection of senior citizens. And the Supreme Court held the DIL cannot be evicted from a shared household under the Senior Citizen Act if she protection protected under the Protection of Women from the Domestic Violence Act 2005. And and evict this and there is a case are there where parents claim their son for neglecting and mistreating them and allow the son to stay in a part of house but restrict him from encourage, encroaching on other area. And the court found no evidence for further mistreatment and ruled the eviction is not mandatory in every cases and and strengthen the senior citizen right to seek maintenance and prevent the misuse of eviction law against the children and also ensure the fair consideration of competing claim before the eviction order.
So this article talks about the recent Supreme Court ruling, where the Supreme Court ruled that the senior citizens can't automatically evict their children from their home under the Maintenance and Welfare of Parents and Senior Citizens Act 2007. And this law is basically meant for helping elderly parents who are unable to support themselves, and it allows them to ask for maintenance from their children or even relatives and gives them legal support through special tribunals. And one important part of this law is that the Section 23, which basically says that if a senior citizen gives away their property to someone on the condition and that the person will take care of them, and the person fails to do so, then the property transfers can be cancelled. Based on this, the court have allowed eviction in some cases, and In a 2020 judgment, the Supreme Court said that the tribunals do have the power to evict a child or relative if it's necessary for the protection and the welfare of the senior citizen. And however, the court also said that each case must be considered carefully and eviction should not be ordered unless it's truly needed. And in the recent case, the court refused to evict a son because there was no clear proof that he mistreated his parents after an earlier order was passed, and the court said that eviction is not compulsory in every case, and decision must be based on the specific situation. That's all from my side.
Yes, basically, this is um, there was a case in the Delhi High Court recently wherein um, the parents came to the court and stated that, look, our son has become a sannyasi. Right. We are old, we have invested so much into his education. He got a decent job, he got a decent uh, life, and all the amenities and everything. But this required a lot of sacrifices from our side. And now, uh, towards the in the evening of our life, he has abandoned us. Then uh, the the son basically contended that, look, I have renounced the world. A sannyasi is a person who has given up on the world, and this is something that is there in the Hindu religion also. That there is a you can renounce the world and you can do that kind of thing. There is nothing wrong that I am doing. I am only doing what is prescribed in the and that kind of liberties are reserved to Hindus. So I have renounced the world. So where is the question of going back and indulging into worldly affairs once I have given up on that? Then the Delhi High Court gave a ruling that, look, you might have renounced the world, but you can't renounce your parents. That is not allowed. Why you can't renounce your parents? Because Section 25 of CRPC puts a duty on you to provide for your dependents. And presently, your parents are your dependents, and therefore you have to provide for them. No matter that you may have renounced the world, it doesn't make any difference. Legal obligations can't be bartered away merely by your act of renunciation. That is not possible. So this act that is there in front of us is basically an instance and point which seeks to balance the rights of the senior citizens against the rights of their other family members involving the sons and their daughters-in-law, and seeks to give the tribunal which is constituted for the purpose, which is basically a family court, and the rights that you have to do a careful balancing of the rights and test the legal propositions in the facts that are presented in front of you. And what are the legal propositions which are basically there? That um, um, that the senior citizens are entitled for maintenance and support. Right? But at the same time, their progeny also has a right to stay in the same, say, the rights of residence, or say the rights of livelihood and all that. And this, so what do you have to do? You have to do a fine balancing. Likewise, when the son is married and he has a there is a daughter-in-law in the family, she also has certain rights, and those rights include the right to residence, the right to livelihood, right to shelter, and all those rights. You have to, all that the act says is that you have to carefully balance all these rights and thereafter arrive at a definitive determination, which is which commends itself to the sense of equity and justice, and thereafter you have to provide a just and fair settlement to the parties. So this, in essence, is what the the article talks about. And having seen, and then there are certain interesting instances, specific instances, which we will take up when we take up the questions, and which we will take up right away. The questions are basically saying that where is that? Yeah, 65, question number 65, and it is shown on our screens also. Section 65, 100% correct, so I'll not touch it. Section 106, a daughter-in-law resides in the matrimonial home owned by their in-laws. The in-laws seek her eviction and citing a breach of their rights under the Senior Citizens Act. The daughter-in-law argues that she is protected under the domestic violence. What is the likely? As I told you, the tribunal will try to see the equity and justice in every circumstance and then arrive at a formulation. They will not prejudge the issue on either side. They will instead compassionately and in a detached way see the facts and thereafter arrive at a decision. They will try to balance the claims based on equity. So C seems to be the correct answer. Daughter-in-law will not be evicted as a rights under Domestic Violence Act take precedence. Daughter-in-law will not be. This is not what it says. It says that you keep in mind the competing interests and thereafter take an equitous decision within the facts, right? Then you have section 107, the question 107, which has already been replied to. Now 108, senior citizens transfer a property to their daughter, stipulating that she should maintain them. After receiving the property, the daughter sells it to a third party. Can the senior citizens enforce the right to maintenance against the new owner? So, enforcement of the provisions against the new owner would be a little this thing, because if the new owner did not have any notice of the obligations of the superior obligations which attach to the property, then it would be very difficult to enforce those obligations against them. Nevertheless, the daughter can be visited with. Daughter will not be allowed to escape from the obligations with which the gift was made. The obligations and the gifts. Either you give up the obligations and you accept the gift. That is not possible. You can't take the gift and do away with the obligations. You take obligations and the gifts together. Therefore, the daughter-in-law will not be able to escape from the enforcement. So the person in whose favor the property has been estranged, that person will take the property without the covenants which come with the property, if they did not have any knowledge about the covenants. But then it is very difficult to say that they did not have any knowledge about the covenants, because the gift deed will contain those covenants. So from it, you see, look at a practical perspective, it is not that easy to argue that, look, we did not have knowledge about the covenants. Now you could have read it and you could have acquired the knowledge. You are expected to be show due diligence in your affairs. Therefore, the practical side may not show up in the way that it is showing up here. Practical side will have certain problems. It will not be such a smooth run for anyone to get out of those obligations. Anyway, having said that, I go to the next question. 109th question. Senior parents seek to evict their son for harassing them to transfer the property to him, arguing he is legal heir and character of property is ancestral. Can the tribunal order eviction? First one is yes, because the harassment to transfer property violates obligations on the senior citizen. No, because being a legal heir gives a right to reside in the property. Now, because now you see, the nature of property is ancestral, and you can alienate what you have. I mean, what rights you have, only those rights you can give away. You can't give away those rights which you don't have. You following what I'm saying? Arguing he is a legal heir and character of the property is ancestral, then how will you exclude him? Suppose it is your self-acquired property, you can do whatever you want with the property. But if the character of the property is ancestral, then how can you give away a right which you don't have? I hope you appreciate what I'm saying. Suppose some property is coming in the family from 2 or 3 generations before the present generation. That is to say, the ancestors, it is an ancestral property, it is coming down from the ancestors to you. In your the hands of your parents also it was ancestral, and in your hands also it is ancestral. Thereafter you say that you say to your parents, immediate parents, that look, the property is ancestral and I have a right in the property. You have a right in the property, matter comes to an end. Therefore, there is no question of any eviction in such circumstances unless you are hit by other provisions of the other provisions of this, in which case the court may grant partition because you have a right. Your right cannot be defeated. Now, question number 110 is 100% correct, so I will not take it. Then please come to the passage number 18.
So this passage talks about the Supreme Court of India has decided that all judges, including the CGI, will publicly declare their assets. There's a case where a large amount of cash at the residence of Delhi High Court Judge Yashwant Verma is found. And unlike the politicians and government official, judges are not legally bound to disclose their financial holding. And the Supreme Court had previously adopted a code of ethics that include asset declaration, but most of the judges just did not make them public. And the testament of the value also established in-house procedure for the investigating the judges accused for misconduct or corruptions. The void action that erode the public trust, justice must be seen to be done, and judges must not contest election or express their political view. Judge must not hear case involving family or close friend, and judge must not give interview or publicly discuss cases. And the judge must not speculate in stocks or engage in business, and do not accept the gift or any type of hospitality from except from close family, friends.
So the Supreme Court on April 1st had decided that all its justices, all its judges, including the CGI, will publicly declare their assets. Now, this move is following the scandal that involved bags of cash found at the residence of the Delhi High Court Judge Yashwant Verma. So, unlike politicians or civil servants who must declare all their assets, judges are not legally required to make such statements and have usually refrained from doing so. Now, judicial ethics was based on a 1997 code, which is the Restatement of Values of Judicial Life, which is a 16 point code of ethics that was adopted by the judiciary to guide and conduct its accountability. So, this document is basically the principle that judges must abide by and must also be seen to do by their peers so that they can maintain public trust. So the key values of the 1997 code include judges should not do actions that erode public trust in the judiciary. They must not participate in contesting elections or hold executive offices in associations. They must maintain distance from the practicing lawyers, especially if they're related. They must be impartial. They must maintain political neutrality. They should not appear in any media interviews or public commentary. They should have financial discipline. They should not disclose their financial interests and should not be recipients of undue gifts or hospitality, and must also maintain professional distance in between themselves and maintain personal dignity. So the current move is it may be a voluntary initiative, but in the future it may set a precedent and add on to the current code that judges abide by. A addition to the judiciary's accountability and public trust seeks to rebuild credibility and prevent corruption, particularly in light of the recent controversies involving the Delhi High Court judge.
This article talks about the recent Supreme Court ruling in which the Supreme Court decided that all its judges, including the Chief Justice of India, they will now publicly declare their assets, and This decision came after large bundles of cash were found at the house of a Delhi High Court judge, Verma, raising concerns about transparency in the judiciary. And so far, judges were not legally required to share their assets like politicians or government officials. But this new step aims to build public trust and promote honesty among judges. And it also follows a set of ethical rules for judges, which is the 1997 Restatement of Values of Judicial Life. And this code of conduct tells judges how to behave both in and out of the court. And the key provisions of this code is judges should not accept gifts or benefits from any other than their close family or friends, and they should also avoid political involvement and not comment on political issues in public, and they must stay away from cases involving their close family or friends, or where they might have a personal interest, and judges must not do business or trade in shares except for small personal investments, and they should avoid actions that might make people doubt about their fairness or honesty, and uh, and the court also reminds judges to behave in a way that maintains the dignity of their position, because they are always in the public eye, and this move is seen as a major step towards ensuring judicial accountability and public confidence in the justice system. That's all from my side.
Look, this is about restatement of values of judicial life. This is a 1997 document, which was accepted by the Supreme Court in a full court meeting. And voluntarily they decided to adhere to this code of conduct. And this is the official code of conduct, and it has been reiterated recently. It contains a list of do's and don'ts. So um, let us discuss those do's and don'ts one after the other. And it is saying that yes, must avoid close association with individual members. This is where it starts. Such family members cannot be permitted to use. Must avoid actions that erode people's faith in higher judiciary. Look, what is important here is that look, what is the asset of the courts? You see and compare the courts with the executive. Then what is it that the executive has? It is powerful, very, very powerful. It has the police, it has the army, it has all the government establishments which are running, and their composition it decides. So it is a very powerful body. Similarly, the legislature is coming from, or you can say the partly the executive is coming from the legislature. There is an overlap with the parliamentary form of democracy. So you can say they are also in a way quite powerful. They make laws and that kind of thing. Now, what powers the judiciary has? Judiciary has the powers which are basically enshrined in the statutes. They they do make laws, but they make the laws by filling the interstices between the statutes. That is the gaps, legislative gaps which have been left out. Whenever the parliament will make the law, it can't be a perfect piece of legislation which envisages all situations. It's not possible. They have to make a law which, to the best of their mind, will project in the future and will survive and serve the nation in the future, survive the changing society's dynamics and continue to serve the nation. Now, that may not always be feasible if you don't have an organic interpretation of the law. That it is the same constitution several years ago, but now if you examine the interpretation which has been given to various provisions in the constitution, you will start wondering that was this the same constitution which was enacted by the, for example, Article 21 of the Constitution. If you have a look at Article 21 of the Constitution, I'll just for a moment I'll pull out Article 21 of the Constitution and show it to you. Article 21 of the Constitution provides that, here it is. says no person shall be deprived of his life or personal liberty except according to procedure established by law. Now, except according to procedure established by law means that you have to see the procedure and say that whether it is duly established or not. What do you mean by that? What you mean by that is that yes, it was a procedure which was prescribed by the law. What do you mean by that? That means the parliament which made it, whether they had the requisite majority, that has to be examined. Yes, they had the requisite majority. Once they had the requisite majority in the house, which is 50% plus one, you examine the Constituent Assembly dictates and say that look, this is a procedure established by law because it was passed by requisite majority. Matter comes to an end. The Supreme Court says something else. Supreme Court says this procedure established by law has to be a fair procedure. Nowhere it is written that it has to be a fair procedure. Nowhere it is written. So it has become more akin to the American due process. Due process means implies the fairness, the reasonableness, the absence of arbitrariness. All that is implied. The moment you say procedure established by law becomes technical, but due process of law becomes due process. It has to be due. It has to be due according to reasonableness. It has to be due according to all that. So you see, this, in some cases, the court initially interpreted in A.K. Gopalan's case that look, it is procedure established by law, and it is not within our puzzle to examine whether the procedure was fair, just, and reasonable. But in Menka Gandhi case, two or 2.5 decades later, the Supreme Court says no, the procedure established has to be a fair procedure of law. So this is what is this happening? What is happening is the society is evolving. The aspirations of people are evolving. What is constant in life is change only is constant. Nothing else is constant. So principles, values, morality, for example, we have seen Hicklin's test, and then we have seen the community standard test, and then we have seen the Miller's test. What is this happening? This shows how dynamic is the process. It is not a static process. Therefore, courts have a very onerous responsibility to advance an interpretation which is in sync with the times. And therefore, the law enacted by legislation, you will wonder that in the 19th century, these laws were enacted, IPC and CRPC and your BNS, which has been enacted in 2023, borrows heavily to the extent of 95% from the IPC, which was there in the 19th century. Apart, of course, it has certain valuable additions and valuable edits and revisits. Those are there. But then 95% of the code is the same verbatim reproduction of what was there in the 19th century, right? So what is this that is happening? So the law has to be interpreted and it has to be kept current, and that itself is the onerous task of judiciary. So the institution that does it must have faith of the people. So what is it that the judiciary thrives on? Judiciary thrives on only on its reputation. That's all. Judiciary doesn't have the paraphernalia, the pelf, the power that the executive or legislature enjoys, but it has the only thing that is there is the reputation of judges. That's all. The reputation it enjoys, and that reputation is very jealously upheld by the powers of contempt of court. That is why contempt of court powers have been given to the judges, that if their orders are not obeyed, then they can punish such contempt. So, in order to vindicate the reputation that they have. Now, if you must have noticed that in your common parlance also, when two people quarrel, then the person who seems to be on the losing side, but who is having law and justice on his side, equity on his side, often makes a remark that court mein dekh lunga. So what is it that is happening? Court mein dekh lunga is a remark that is coming from a person who has inherent faith in the judiciary. This shows that there is a faith in the judiciary. People's faith is there, that equity, justice, and all those freedoms, all those ideals which are enshrined in the preamble of the Constitution, and with which partly the judiciary is also entrusted with the task of upholding those principles and values. Those principles and values will be will be upheld by the judges, and that is only possible if the certain norms are adhered to, and those norms are there in the judicial restatement of judicial values. Must not contest elections, hold office, clubs, societies, associations. Why? Because if tomorrow a case comes to them regarding the same club, society, association, then the whole thing would become controversial. That is also one of the reasons why they are not required to, you know, they are required to remain aloof from the society, the judges. That is because aloofness, their role is studied aloofness. They have to be aloof. They have to have a cool, calculated, calm and detachment, calm, detached attitudes towards the society. That is what that is the calling of their office. They must avoid close association with individual members of the bar. You can't be, the lawyers are appearing before you and you can't act chummy with them. That is not done. And if you do, then you are violating the. Similarly, such family members cannot. Now, this has been a very controversial kind of thing. The judges are there, then their progeny is practicing in the same court, and then so many of the judges are there who voluntarily seek transfer to other courts when their family members start practicing there. That also happens, but those judges are not very many of them, because people are very wise. They see that, oh, he is the judge's relative. Let us go to him. Maybe we can get a better relief. So that would be very inimical to the idea of justice. Must practice a degree of aloofness. We already discussed impartiality. Since they are required to be impartial, therefore aloofness is also essential. Must not hear and decide where a family member or the friend is involved. So if the family member is involved, if the friend is involved, or if the judge has a pecuniary interest in the subject matter of litigation before him, he has to recuse himself from the bench. He has to say that, look, so and so is my family member. One of the parties to the dispute is a person who is known to me. I mean, is a family member. Or he has to say that the company which is there in front of him as a petitioner, I also hold shares in that company. However insignificant maybe the amount of shareholding he has, he may have only 1 rupee. It makes no difference whether he has 1 rupee or he has 1 crore rupees. It makes no difference whatsoever for the purposes of law, because the law should not only be administered fairly, but it should be seen by the public to be administered fairly. So the moment you have a pecuniary interest in a company, the company is a litigant before you in a matter or a cause, then the propriety requires, and this is what the judges normally do. That propriety requires that he will request the Chief Justice. He will pass an order, and in that he will make a request to the Chief Justice to constitute a different bench, because he has to recuse from the bench as he has an interest in the subject matter of the dispute, and therefore he is not competent to decide the dispute. Now, must not publicly express views on political matters. Now, judges are required to stay away from the political thicket. Judges are not expected to get into politics. The moment they start dabbling into politics, it creates a problem for the constitutional upholding of rights. Because many a times, if they start dabbling into politics, then they will be taking sides based on political ideologies, not based on the constitutional ideology. So they have to be true to the constitution, not to the political thicket. They have to maintain their distance from the politics. Because the moment they get into politics, the quality of judgments, and the judges must let his judgment speak. The judge should not be a chatterbox, either on the bench or off the bench. He is required to maintain his dignity and speak less. When you don't speak, don't you overindulge in speech, then that gives a very bad impression. So that kind of impression the judges are not supposed to give. Not accept gifts or hospitality. This is there for judges, and this is there for everyone else also. You can't accept gifts. This is what the Prevention of Corruption Act is all about. Must hear and decide matters involving a company, in which this we already discussed. If you have a pecuniary interest in any subject matter of a dispute, in one of the companies, in one of the litigators, if you have if you in such litigator you have a pecuniary interest, you must get out of that situation very quickly. Otherwise, if you don't, then what happens? Then your judgment can be set aside in appeal. Just like in Justice Deepak former Chief Justice Deepak Mishra's case, Constitutional Court, the Supreme Court of Singapore set aside his arbitral award because he pasted portions of his own previous rulings. When the court was of the view that the Supreme Court was of the view that Singapore Supreme Court was of the view that this is prejudging the subject matter at hand, he should have applied his mind independently and not copied pasted from his earlier judgment. Although the judge may not have made a mistake on the point of law, but then justice is not merely about law, but it is also about being seen to be doing the justice. It is the bar is very high. You should be seen to be doing justice also. You should not merely do justice. But they say that not only Caesar, but Caesar's wife should also be above suspicion. That kind of thing is there. Here, the moment there is a slight bit of suspicion that there might be a prejudging, that is prejudice, there might be an interest, it kills the idea of justice. Must not engage in any trade or business directly or indirectly. And you can't basically suppose there is a what we call as there is an auction of a property. You can't be an auctioneer and you have given the judgment. You can't go ahead and purchase that. So the auction is there and I have given the judgment. Now let us go ahead and purchase that property. That kind of thing is not allowed. This kind of dabbling, debutant, this kind of thing is not allowed. Should not seek any financial benefit connected to our office unless clearly available. So in one of the cases, the judges applied for permission to receive money for publication of three small books, and he was receiving a lot of money. He applied for permission, and it led to opening a Pandora's box, and all kinds of hue and cry started coming in the press that look. Who will pay for these three small books? This was royalty. Something else is going on. So one has to be very clear about what he is receiving and whether not only the receiving part should be correct, but also that it should be seen to be correct. That is also important. Must be conscious that he is under public gaze. That is there in case of any public servant, for that matter. That is there in case of a district magistrate also, in case of an SDM also, in case of a district judge also, high court judge also. You are under a public case because you are a public functionary. So many of these things are basically common to all public officials, not merely to judges, not peculiar to judges themselves. And some of them, yes, particularly with respect to your reputation as a judge, because judges survive only and only on reputation. Therefore, reputation should be absolutely free of blemish. So that part is very important because that has a direct implication for the kind of faith the people will have in you. The people should have absolute faith in judiciary. Then only the constitution and the democracy can thrive. There will always be a tension between the judiciary and the executive, the judiciary and the legislature. There is no such thing as a happy relationship between them. There will always be a tussle of power because you are putting the norms, you are showing the norms you are showing the mirror to the executive, you are showing mirror to the power, the executive, that look, there is a constitutional restraint on your power. Therefore, there will always be a tension. Therefore, when Dhankad makes a speech in the parliament, what is happening? Judges are setting limits to the presidential power. Yes, sir, they are setting limits to the presidential power because the constitution says them to do so. So this is a tension. And this kind of tension is good for democracy. Mr. Dhankad is entitled to his views and to express his views also. But the others may differ from. There's nothing wrong with that. He is expressing his views. He need not be silent. He has expressed his views, but he might be misguided in his views. The others also should have an equal liberty to say that Mr. Dhankad is misguided because because this is not what the constitution says. Judges act in terms of the constitution. When judges, governors can't hijack the popular ministers, and this is exactly what the Supreme Court has said, and therefore they have to comply with that. Now, what happens if there is a person who has a shady credentials? In the first place, can he say that the governor has to remain within the limits of his powers? He won't be even able to say that. So the reputation, the person must be solid in terms of integrity. Person must be solid in terms of professional competence. Then only it is possible to become a judge of a constitutional court. It's not that easy otherwise. All right. So I, having said that, let me quickly finish up the questions, and I take up the questions one after the other. Question number 111. This you have answered correct, so I will not take it up. This 112. Own shares in a technology company. I have already told you that the moment you own shares, the proper thing for you to do is to recuse yourself from the bench and not hear the case. If you hear the case, your judgment would be set aside whether you have 1 paisa of share or 1 crore of share is irrelevant. Right? So you have to recuse yourself from the bench. You have to get out of the bench and say that I have an interest in the subject matter of the dispute. However, interest is big or small is irrelevant. Then 113, judge is offered an expensive gift. This you have answered it correct based on your reading of the passage, so I need not elaborate on this. Retired judge known for his landmark judgments decides to publish a book called Legal Philosophy. Does this activity align with the restatement of values of judicial life? Publishing books, judges are allowed to do that. There's nothing wrong with that. That is a scholarly thing. That is a very creative thing. There's nothing in the statement of values which is prohibiting that kind of thing. Then 115 is also correct, and that is the last question. Tomorrow we will take up the logical reasoning part of this, and then this will be over. All right, beta.
The lecture series revolves around discussion of mock papers. You can request us for the concerned mock papers. If you intend to join us in our daily discussions, you are most welcome.